Corvette.
Hi, and welcome to this edition of Nevada Legal Services Now for our Thursday live presentation. We are going to be presenting on mobile homes. One of the things that we do at Nevada Legal Services is represent tenants in eviction cases. And that includes owners of mobile homes who live in mobile home parks or who are living on land. Again, I am Ray Gertkin with Nevada Legal Services, and I'm joined by David Olshan.
That's me with my name at the bottom.
Yes, obviously, yes, we do have our names at the bottom. But thank you for joining us today. And definitely, if you guys have questions, please add those questions to the live chat and we will get through them either as we go or at the end. But we'll go ahead and get started. So the sources of law we're going to be talking about today are the eviction statutes in the Nevada revised statutes. So we're looking at the eviction procedures, fair housing rights, a little bit about RVs, and then the big one for mobile homes, which is 118B. And then finally, we'll talk about liens, but the lien statutes are in Chapter 108. So mobile home evictions are generally governed by 118B and then Chapter 40, which is the eviction process. So we're really talking about mobile home owners in mobile home parks generally. Now we're going to talk a little bit about mobile home parks, but you might not actually live in a park, but it might qualify as a park. So just keep that in mind as well. The one thing about owners of mobile homes is that you have to be evicted through the formal process. There are two types of eviction processes in Nevada. There's the summary process, which applies to generally regular landlord-tenant relationships. And then because mobile home owners have a home ownership interest in their home, we also need to talk about the formal eviction process. So essentially, you will need to be affirmatively sued for eviction in order to be removed from the park. So we're talking about removing the home from the park, essentially.
Right. And, Professor Olshan here will correct you, Ray. I think there's at least 4 different eviction procedures in Nevada. There's housebreaker, there's self-help. So just a fine point to make me look smart. The other thing is it's important to know that it's like you own the mobile home and you don't own the land. So you're kind of like a tenant, but not a tenant. So that's why you're entitled to these greater protections under Nevada law.
Right. And thank you for the clarification, David. It's always
just call me professor.
Always important to be accurate. And then the one other thing that is a common and frequent occurrence in the land of mobile home ownership is that you might be subject to a lien. So if you do not pay rent, the mobile home park does have a legal right under Chapter 108 to put a lien on your mobile home for unpaid rent. There are rules and a specific process that goes along with that. But it is possible that you may have a lien and the eviction itself might be tied to the lien execution process. So please be aware that if you do not pay rent, it is probably more likely you'll have a lien on the mobile home, but you would eventually potentially face eviction as well. And then if an RV, and I talked a little bit about the definitions of a mobile home park. If it's an RV in a mobile home park, the RV usually qualifies for mobile home protections. Generally speaking, RVs have lesser protections against eviction because you're in an RV, it should be mobile, you should be able to drive off. But if it qualifies as a mobile home park, depending on kind of, the status of the space and the lot and how they're managing it, the RV could qualify as a mobile home for under Chapter 118B.
And it's important to also, we'll get into this later, but even if you don't qualify for 118B protection, you're still entitled to Chapter 40 protection. So if you're living in an RV and it's not a mobile home park, the landlord still has to give you an eviction notice.
Correct. And Chapter 40 still applies for evictions. All right. So again, kind of talking about the definitions of when Chapter 118B applies. It doesn't apply to manufactured home parks that are operated by a housing authority. I am not aware of any of those in Northern Nevada, David. I don't know, does the Southern Nevada Regional Housing Authority operate?
Yes, Rulon Earl Mobile Home Park. Rulon Earl was a lawyer, and he basically gave this land to a housing authority, and it's for lower income people, but it's operated by the housing authority. It's owned by the housing authority. I think JC Mobile Home Park is the same way. It's owned by the housing authority.
And the reason for this is because the public housing, those protections are greater than potentially than Nevada landlord tenant law. So in that sense, that is why there's an exception, is because there's federal rules that come into play. But we are looking at a lot in a manufactured home park, which is rented or held out for rent overnight or for less than 3 months. That's an RV park. So that's when 118B does not apply, is when it's for less than 3 months or only held out for rent for like nightly, essentially.
What's it called? Good Sam RV Park, like when you're traveling and you stay like overnight or for a period of less than 3 months. Sam's Town is what I think of, is they do have an RV park there for people to travel, especially, the snowbirds. So, those are not manufactured home parks or mobile home parks. Those are RV parks.
Right. And so if we're talking about less than 3 months, then this is not a mobile home park situation that 118B would apply. And then again, for recreational vehicles located, if it's for, as David was describing, that also doesn't apply. And then any lot in an actual mobile home park that is used only for recreational purposes. So this is, again, sometimes RVs qualify as mobile homes in mobile home parks, sometimes they don't. So it really depends on sort of the length of time that the renting is happening, so to speak. All right, and then those definitions are also in 118B. And again, we're looking at more than 1/2 the lots are rented out for less than 3 months for RVs, then you're not a manufactured home park. Or that area, I guess, is not.
I would just point out how complicated this is, and it doesn't need to be. You have 118B 016 and then 118B 017. They both define manufactured home park, but they contain different conditions. So, legislative, statutory construction, you have to read them in harmony, and sometimes it's hard to do that. So
that is true.
That's why we get paid the big bucks, because we're the lawyers and we can figure it out.
Supposedly.
Right.
All right. Well, but we're just talking about definitions. It does come up. So, especially with RVs and manufactured home parks, does that RV qualify as a manufactured home? But for the most part, if you're living in a manufactured home park, you entered into a lease agreement with the park, then this generally is not going to be an issue for you. One of the things that does come up is if you're renting just on land and it's not called a park, but there are more than 2 RVs that are rented out on that land, it could legally be considered a mobile home park. So just, keep in mind that if you own your mobile home and you're renting it on land, Chapter 40 is going to apply anyway. Whether or not Chapter 118B applies will depend on the definition. So that's just, kind of the overall scheme of what we're talking about. But for the majority of people, you're probably in a mobile home park and have lived there for quite some time. And again, this is what I'm saying, 2 or more spaces or homes, more than half the homes rented for longer than 1 night, more than half the RVs rented for longer than 3 months, and homes are used for permanent residence. That's what we're talking about when we're talking about a manufactured home park, just in general.
Why couldn't they well, anyway, I won't.
Right. Why couldn't they have written it like that? Yes. Okay. So we've been saying that Chapter 40 governs the eviction process. That includes service of notice under Chapter 40.280. And then there's different notice periods. So you have a 5-day notice for a nuisance defined in Chapter 40, what constitutes a nuisance, and that's a 5-day notice. There's a 3-day nuisance notice for specific issues. These are things like discharging a weapon, illegal drug manufacture, and some more like heightened sort of nuisance behavior. Then there's the 3-day notice. But generally for general nuisances, we're talking a 5-day notice. It's a 10-day notice for non-payment of rent, which includes utility charges and reasonable service fees. And then the 45-day notice is generally for any other reason, but always for cause. If you own your mobile home and you live in a mobile home park, you can never be evicted without cause. There always has to be cause to terminate your rental agreement. And then finally, the 180-day notice. Mobile home parks can change. They can get sold. The new owner might want to change it from a mobile home park into something else, maybe a strip mall or a commercial development. That's possible, but it has to involve a 6-month notice. And there's other provisions that apply for, the moving essentially your home if it changes. So there's a whole other scheme that comes into play if the park is going to change ownership. And that does happen. But more frequently, we're looking at, removing one home from a park because of a reason that the landlord wants to evict a home.
Couple of points. First of all, these notices are contained in 118B. So that's why it's important to figure out if 118B applies, because then these notice periods and these notices will apply. And the second thing is, I don't know, this is a long time ago, but when Treasure Island was built, there was a mobile home park, and they were trying to, Wynn was trying to buy it and force the people out. And there was a political sort of kerfuffle. And so they basically built Treasure Island around the mobile home park. But yes, land, especially here in Southern Nevada, is valuable, and you can get more money if you build a casino or housing or things like that than operating a mobile home park. So we haven't seen it lately. Of course, the pandemic changes everything. But living in a mobile home park, you could think you're safe and that you can live there for a long time, and then somebody will come along and buy it, and you're kind of screwed because they can give you this 180-day notice.
And yes, and there are, as David said, the notice provisions are in 118B, as are the grounds for eviction. It is technically 2 separate sections, but again, you have to read them together. So there's a notice provision, and then there's a cause sort of grounds provision. But as a mobile home park owner, you do have rights defined in Chapter 118B. Some of those rights are you're entitled to 90-day notice of a rent increase. The landlord is responsible to maintain the common areas and make the park, get rid of snow removal. Obviously not a big deal in Southern Nevada, a bigger deal in Northern Nevada. Keeping, care of the trees and other things in the common areas. Of course, the tenant is responsible to maintain their lot. But the landlord is responsible for maintaining the roads and the common areas of the park. That includes abandoned or unoccupied lots. So the landlord is also in charge of making sure those are maintained. The tenant is responsible for the tenant's lot. Of course, it depends on the lease in terms of what the landlord is going to keep responsibility over. If the tenant is required to maintain the lot and the tenant does not, the landlord can do it and charge the tenant. Again, the landlord is ultimately responsible for the common areas, the abandoned areas. So they might come in and charge the tenant to maintain the lot. If I were the tenant, I would not rely on this because you could also get evicted for it.
There's a lot of, first of all, there's a lot of problems in mobile home parks. There tend to be sort of factions or cliques. And if you're not in the good one, then you tend to be harassed, and sometimes they get lawyers involved and evictions occur. But, when you do have trees, and trees are maybe on a property line, there's always a dispute whether it's the landlord's responsibility or the tenant's or the neighbor's responsibility. So, I don't know what to say. I mean, I would tend to avoid mobile home parks, but if you do, you should try to sort of be friendly with your neighbors and try not to cause controversy, because it's really tragic when there's an eviction and somebody loses their home because, it's your home. And, if there's a dispute about trimming trees, you'd hate to sort of lose your home over, trimming a tree that you could easily do yourself or hire someone, and you end up losing your home. So, just be cautious, because we do see a lot of petty disputes that arise. And most often it's about personality more than substance.
That is true. So another right that the tenant has is the tenant can withhold rent if the landlord is the cause of problems. Sort of, this is the habitability laws. Again, the tenant is responsible for the tenant's own home, but if the landlord has done something that makes the home unfit, like does something to the connection to the electricity or the sewer or the water hookups, if it's the landlord's fault, then the tenant can withhold rent. Again, if it's something that the tenant did, then this doesn't apply. But if it's something that the landlord causes, then the tenant can potentially hold rent if the mobile home is deemed unfit for occupancy for over 48 hours. Again, essential services, the landlord does have to maintain hookups for water, electricity, sewer service. That has to be made available by the landlord. But again, the tenant has the home that has to also have the ability to hook up. So just, whose fault it is may come into play.
Right.
And then 118B 153 does require reduction in rent if the landlord removes a service that the landlord had provided. So generally in mobile home parks, there's a common sort of utility provision where your utility charges can be included with your rent because they're sort of commonly billed. And then you get your apportionment of the utility charge has to be published by the park. If the landlord removes that and says, no, now you're responsible for your utility charges, that has to include a reduction in the rent. All right. Again, the landlord can't interrupt any utility service to make the tenant move out. Similarly to regular landlord tenant, the landlord is responsible for actual damages if they somehow make it so the tenant loses electricity, water, or sewer access. And again, we talked about the reduction in rent if the landlord if the mobile home park removes a utility service, that then is the responsibility of the tenant. And the Manufactured Housing Division does accept complaints, and they do investigate complaints for violations of 118B. If the park is doing something that violates 118B, you can complain to the Manufactured Housing Division.
And, it's important to sort of remember that the landlord is responsible for providing the hookups for electricity and water. And those are usually the two biggest issues. The water charges are too much, or the water is discolored, or the electricity isn't working. So if the landlord does provide sufficient hookups, then that's really the landlord's responsibility. If the water doesn't come out of your faucet, in residential sort of landlord-tenant law, it's the landlord's responsibility, but not in mobile home law. You're responsible for that water to come out of the faucet if it's provided to you at the hookup.
Correct. All right, so we also talked about liens for unpaid rent. Again, I said there's rules and a process for placing a lien on a mobile home. This is contained in Chapter 108, and basically it's all about timing. The mobile home park does have to look at the timing of when rent is due, and they have to they have to essentially go with what the timing says in order to place a valid lien. If anything is not placed correctly, the lien could be deemed invalid, and there is a possibility for the mobile home park tenant, the owner, to challenge a lien from the mobile home park. So that is a possibility if the landlord has done something wrong in placing the lien on the home. This also has to be preceded by a 10-day pay or quit notice. The tenant does have 10 days to pay to satisfy the lien. Again, the landlord can then sell the home to satisfy the lien. That's a non-judicial, essentially, foreclosure of the home that does not have to go through a court process unless the tenant objects to the lien. There is a time, it's very similar to foreclosing on homes. There's a 4-month lapse between when the notice is provided about the lien, between the actual sale date and the notice of sale, and then the actual sale date. According to statute, the lien can't exceed $2,500. So just keep that in mind. You still owe more than that potentially, but the lien could potentially be satisfied up to $2,500. Once the home is sold, then we're going back into the eviction process, because in order to remove the home from the park, there does have to be an eviction, but essentially you could lose ownership of the home through this sale process.
And it's important to know that like a local law firm here in Las Vegas will give you an eviction notice along with a lien notice. So you'll address the eviction, but not the lien, and the lien will be foreclosed and sort of you'll lose title. So the eviction won't really matter. They'll follow through just to get the attorney's fees, but you need to address both. If you're getting a lien notice and an eviction notice, you need to address both. And that's really the problem here, is that there is this sort of mechanics lien on the mobile home. If you don't own the space and you don't pay it, they can basically take your home for pennies on the dollar. Like $2,500, your home could be worth much more than that, but they're going to foreclose and they're going to take their fees and everything else out. So it's really important to address the lien notice, because if you don't, you're going to lose title to the mobile home.
Right. And again, I mentioned the formal process, and David corrected me that there are 4 eviction processes. We're going to talk about the formal eviction process, or the most formal eviction process, because you cannot use summary eviction for mobile homes. That means that after you receive the initial notice, and we talked about the 5-day or 3-day nuisance notice, the 45-day other cause notice, the 10-day rent notice, after that notice is issued and served on you, according to 40.280, the landlord has to file an actual complaint, which is filed in court and then served on you with a summons in order to answer the lawsuit. So it's an actual lawsuit for eviction, and it goes under Chapter 40 and 40.300 through sort of the end. I guess maybe, I don't know what the end is, but there's a couple of provisions under Chapter 40, but it starts with 40.300. The complaint has to be verified, and you do have a right to request a jury trial. You would generally be provided with 20 days, although you can, the park can ask that be shortened, but it cannot be shortened to less than 10 days. So generally speaking, be prepared to answer. You will have to, in order to answer, you would generally file something in court. The other thing that has to happen with mobile home cases, you cannot be evicted without a hearing. So in any respect, before you're evicted, generally speaking, you'll have the opportunity to have a hearing. You do not have to file an answer before that hearing, although it is always advisable to get your arguments in writing filed with the court before the hearing, so that everything is on the record in case you have to appeal.
Right. I mean, we're going to talk about it, but there's some sneaky people who don't request a temporary writ. So they'll just file the complaint. And if you don't answer, they'll move for a default. So it is very important to answer the complaint, because if nobody requests a hearing, I don't think it's allowed, because you have Farno versus District Court that says you don't get evicted from a mobile home until you have a hearing in court.
Right.
But still, it's sneaky, and some attorneys do that. They don't request a temporary writ hearing, so you do have to answer to oppose the eviction.
There should be a trial scheduled, though, and that trial can't be scheduled for 21 days. But I do agree with you that it could happen that they try to get a default. Now, as David mentioned, legally speaking, there has to be a hearing before you're evicted. But again, at that point, you're relying on a court or the landlord's attorney to know what's right or do what's right. You want to protect yourself. But as David mentioned, there is a process that a lot of landlords file where they can request that you be removed from the home while the case is pending. And that's called a temporary writ of restitution. It's kind of backwards from normal sort of injunctions. I know I'm getting technical when I say injunction, but this is essentially a way that the landlord can actually say, no, you should leave the home before the final order is entered evicting you, because essentially the eviction is on a reason why you shouldn't be allowed to stay. I think that they should have actual showings of facts and circumstances that make it sort of emergency. I mean, this is an extraordinary process, removing somebody from their home before they have a chance to have a trial, but it is allowed under Chapter 40. Now, you do have to have a hearing with a temporary writ of restitution. That hearing cannot be scheduled until 11 days after you are served with the complaint. And again, remember that generally includes a request to shorten time to 10 days to answer. So this is all happening within 11 days if they request a temporary writ of restitution.
And I would just note for trivia purposes that, this unlawful detainer process goes back to at least 1937 when Nevada compiled its laws, and probably back to 1865. So why do we call it temporary writ of restitution? It's not really a writ. It is restitution, but not sort of the way we view it today. But that's what it's called, and that's part of the plenary process.
And again, I can't stress enough how, this process should be for extraordinary reasons. This should not happen for your generic, they didn't pay the rent, we just want them out, they gave a 45-day notice. I mean, we really should be talking about nuisance behavior that you're damaging the home or the park. I don't think that's what happens, but I do think that that is the standard that as a tenant you should be looking at and challenging the landlord that, like, just because they think that they're going to win because I owe the rent doesn't mean that they should be entitled to this extraordinary measure before the trial is set 21 days. So,
I think they file it in every case except the ones that they want to be sneaky. So, I know what you're saying, Ray. It seems only for waste or nuisance or, criminal activity, but it's as simple as I haven't paid the rent for 1 month, so they'll move for a temporary writ of restitution. And, judges don't bat an eye. It's like, oh, this is part of the process, so let's just do it.
Right. Now, there should still be a trial scheduled because this is a temporary process. Now, that's something that rarely happens because once the tenant is out, everybody just moves forward as if the tenant was finally evicted. But technically, there is still supposed to be a trial scheduled. Again, not within 21 days of the complaint, but this temporary writ is technically supposed to be temporary. The landlord is required to post a bond to indemnify the tenant if they end up winning at trial. So technically speaking, a trial is still supposed to be scheduled, even if a temporary writ of restitution is granted. And the landlord is required to post a bond. If the tenant is eventually let back in, the tenant is entitled to that bond as damages for the time they were out of the unit.
I mean, I don't want to call it a sneaky thing, but sometimes what I've seen is at the temporary writ hearing, counsel for the landlord will say, I would like to convert this to a permanent writ of restitution and ask that the judge enter that order. And it is allowed under the law. It does sort of help you. I mean, the landlord doesn't have to provide a bond for the temporary writ, but the permanent writ does allow you to appeal. Not that it's such a great thing because you're permanently evicted, but with the temporary writ, you do have the ability to go back if you win at trial. Like you said, Ray, it never happens. So, if you are in one of these situations, I don't think you can appeal a temporary writ of restitution. So if you're at a hearing, you probably should ask for the permanent writ because that would give you the right to appeal.
But just remember, if you do appeal, then you have to post a bond. So the bond requirement does switch. And the judge can set the bond. They can't set it more than 3 times the amount of rent, but they can set a bond that may be cost prohibitive. So yes, I hear what you're saying, but I think you have to weigh sort of what is more likely to happen. If it's only a temporary writ versus, and requesting that a trial be scheduled versus the permanent writ and having the ability to appeal.
And it really is, Hobson's choice. Like, do you let the temporary writ go in? That means you're evicted and you may have the opportunity to have a trial later, which is sort of probably not going to happen. Or do you ask for the sort of permanent writ to go in and then you can appeal it, but you do have to post. I mean, you don't have a choice really. And it's sad, but that's kind of what happens.
So we've already sort of talked about this, that it can't be a substitute for a trial. I would object. Well, again, you can consider whether objecting to the judge not scheduling a trial if it's a temporary writ or the permanent writ. And the trial cannot be set on an order to show cause, which is how they set the temporary writ of restitution hearings. So, there are potential procedural issues that could come into play. And then again, no default judgment can be entered prior to actually having a hearing. So, keep that in mind. If there is something sneaky and you're evicted without a hearing, you should appeal that decision.
It's kind of bringing back bad memories, because the only jury trial I had was in a plenary eviction, in which on Monday, I opposed the temporary writ of restitution and asked the judge to grant our right to a jury trial, and the judge did, but he did it for Wednesday of the same week. So there wasn't really much time to prepare. And, you can use the jury trial, right to a jury trial, to get away with not having to go through with the writ of restitution. But, be advised that if there's a jury trial, there's a jury trial. So you have to basically gamble that the jury will rule in your favor. And, I don't know, in Clark County or anywhere in Nevada where people would be that sympathetic to people, who haven't paid the rent or are causing a nuisance. And certainly our jury was out for like 10 minutes, so we didn't really benefit by having the jury.
All right, so some finer points again in terms of looking at procedural issues, but the complaint does need to be verified, cannot be verified by the attorney. If it's an out-of-state owner of the park, they have to post a bond. As David said, there can be a jury trial. Whether or not that's actually a good idea certainly bears consideration. And then the lien process and the eviction process for non-payment of rent often go side by side. So be aware that you do have to pay attention to both the eviction and the lien. And again, a lien is there's a technical aspect to it. You might be able to challenge it, and you can file a request for a hearing to oppose the lien.
I kind of shorthanded the explanation. There's a local law firm that does a lot of mobile home evictions, and they always have the attorney verify the complaint. Verification is required. If you don't verify the complaint is void. However, you can waive that right if you answer and don't raise it as a defense. But when the attorney verifies the complaint, first of all, it's creating a redundancy. Rule 11 requires the attorney to verify the allegations in the complaint anyway. So they're basically rendering the statute null and void, and they can't do that. So that's one reason why verification by an attorney is wrong. The other reason is if the attorney verifies the complaint, there's a good chance the attorney would be called upon in the case to testify. So when there's a chance that you can be called upon to testify, the rules of ethics don't allow you to represent the plaintiff. And so those are two very good reasons why an attorney can't verify a complaint. It's done all the time. And I think that's why all these complaints, if you are being evicted from a mobile home park, can be challenged, because there has to be verification. And if it's not, if the complaint isn't verified, then it's void.
So that basically concludes our presentation on mobile homes and mobile home park evictions. If you guys do have any questions, please feel free to put those in the chat. We will stay on for another minute or two to see if there are any questions. But again, please feel free to chat us. If you are facing eviction, please, you can, feel free to contact us. We also have information on our website, which is nevadalegalservices.org. You can also complete an online application for assistance on our website by clicking on the online intake tab. You can also call any of our offices, and hopefully we'll have the information on how to contact us in the description box below. But any final thoughts, David, other than what we've gone over?
I think if people are watching this and say that's not how it works here, wherever I'm living in Nevada, just understand that just because a court or a judge has been doing something for a long time doesn't make it right. So we have a situation in the local sort of rural jurisdiction that allowed summary eviction notices to be given in a mobile home park where the person owned the mobile home. That was wrong. We appealed it. We won. But the local justice court was doing it for like 20 or 30 years. So, we are, I don't want to say experts, but we have a lot of experience in this area. And, what we're saying is based on the law, not on the procedure that's out there in some of the courts. And I don't want to pat myself on the back, but you can just look up what I'm saying or what we've been saying and see that we're correct. And maybe some of the courts aren't correct.
That is true.
Right.
Yes. And, again,
Speaking from warriors who get beat up all the time.
it is part of, courts don't always know what they're doing. And of course, they're also prohibited from giving anybody any legal advice. So keep that in mind as well. All right. It doesn't look like any questions are coming in. So thank you everyone for joining us today. I am not sure if we're going to have any of these in December for, just December is a busy month for us. But if we do, obviously we'll post those. But thank you, David.
Thank you.
And we'll see you next time.